Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, ombuds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is CheNweEgbunike, the marketing liaison of Ombuds Day 2024 American Bar Association Dispute Resolution and the host of Expert Views on ADR Ever video podcast show. I'm delighted to welcome Blaine Donas. He is the president and founder of the Workplace Fairness Institute and author. He has spent many years improving working relationships in public and private sectors. Blaine is presently an adjunct professor of workplace dispute resolution at Anconsen College, York University, Toronto. He wears many hats, so I've left the link to his profile. Welcome to the show. Let me stop sharing my slides. It's such an honor to have you, Blaine.
Yes, thank you so much. It's an honor to be here. And I really liked the way you described your mandate because I think all of these things are interconnected. And so I'm really looking forward to having that discussion with you.
Oh, thank you so very much. So without further ado, the first question is, what is the difference between dispute resolution and conflict management, and why is it important for us to understand the differences when it comes to preventing workplace bullying, discrimination, harassment? Thank you.
Yes, thank you for that question. And this is actually a question that has driven us somewhat in Canada in terms of the way that we have that our thinking has evolved in this area. And so let me just begin, if I may, with the discussion about the difference between dispute resolution and conflict management. So according to Abel, Felstiner, and Surratt's a seminal article, Naming, Blaming, and Claiming, a conflict begins with a perceived injurious event. And then there's a number of evolutions that take place before it becomes recognizable as a conflict in our context. And so what they say is that for something to be a conflict, there must be naming, blaming, and claiming. This of course, what Abel, Felstiner, and Surratt is really talking about is a dispute. So this is a conflict for which there is a rejection of the claim, and then there has to be some sort of forum or process within which to manage the rejection of that claim. This is a paradigm that is actually quite problematic in our thinking about psychological safety. Because, and not that that there's anything inaccurate about Abel, Felstiner, and Surratt's, description of conflict and how conflict arises, but across the world, it appears that we have focused on a particular part of that definition. So in other words, that conflict essentially doesn't exist until it is two-party manifest conflict. Mm-hmm. And so what happens with conflict, according to Rubin, Pruitt, and Kim in the book Social Conflict? What happens to conflict is that it takes on a number of transformations. And some of these transformations happen almost immediately. we can see one of the major transformations that takes place once a person experiences a perceived injurious event. One of the split-second transformations that takes place comes from attribution theory, and that is a transformation from specific to general. So it's a transformation from experiencing a perceived injury and drawing conclusions about the intentions of the person who you are blaming. And so this transformation happens almost immediately. Other transformations happen as well. The transformation from few to many. So in other words, conflict can grow. It can grow even though it might not meet the traditional definition of conflict as it's set out by Abel, Felstiner, and Surratt. So let's just sort of take this another way. There's a something has happened in an open office environment in a workplace, that somebody has done something that somebody else has perceived to be injurious event to them. As we understand the social dynamic of conflict, what often happens is that a person, instead of confronting the other person or even having a discussion with the other person, the person who feels aggrieved will go to their support system. And the support system in workplaces is not the structures that are in place, it's the people around them that they trust. So what ends up happening is that individual conflict starts turning into group conflict. And so this is important to understand because virtually all of our structures, or the vast majority of our structures, up until I would say the late 2010s, like 2015 and on, the vast majority of our structures for managing conflict in the workplace that we have identified as conflict management are actually dispute resolution. They're actually, a conflict would have had to have progressed to naming, blaming, claiming, rejection of the claim. It had to have transformed in all of these other ways, and therefore have caused all kinds of psychological harm before the system kicks in. And so this is something that in the context of the Canadian system, there's an evolution of our thinking and of course the Canadian system has provincial and federal jurisdictions, and so and this is important to understand because in the workplace context there are federally regulated employees and there are provincially regulated employees, and these are not federal regulation does not touch provincially regulated employees. 20% of our employees in Canada, more or less, are federally regulated. And the other 80% are regulated through one of the 10 jurisdictions in the provincial jurisdictions. And so provincial legislation, there's all different varieties of provincial legislation. However, a few things have happened in the Canadian context that has started to move federal and provincial jurisdictions in a similar direction. And just to step back here on the difference between dispute resolution and conflict management, one of the things that's being increasingly recognized is that it is too late to try and manage a situation, for example, to manage harassment after the harassment has already happened. Mm-hmm. It's too late. And so where our thinking has gone is that to put it in a kind of an axiomatic way, the best managed conflict is conflict that never happened. Mm-hmm. So the best response to harassment is to ensure that harassment never happens in the first place. Hmm. And this has started to become a focus of our thinking as we move forward. One of the broad questions that was asked for this podcast, was how do people feel safe to report? So let's just think about that. Feel safe to report. Look at what has already happened to them. And look at, and as they experience perceived injurious events, their trust in the system erodes. Because our at least our semi-conscious or subconscious expectation in the workplace setting is that our employer will take care of us. This is one of our expectations. Yeah. We have a duty of fidelity to the employer. The employer has a duty to protect us. So, up until basically 2016 in Canadian jurisdiction, there had been no mention of the employer's duty to protect workers from harassment, or even, in fact, from violence in the workplace. Although functionally violence was covered under occupational health and safety risks. And so there were jurisdictions in Canada that were already assessing for the risk of violence and so on. What happened in 2010 or 2009, or culminated in 2009, let's put it this way, in Canada, is that in the Ontario jurisdiction, there was a very high profile case that led to where two high profile cases. The first one was a nurse in a hospital in Southern Ontario who had a relationship with an anesthesiologist. And that relationship sort of, went south, and she tried to end the relationship. And the anesthesiologist wouldn't let it go. And he got increasingly more destabilized as the weeks and months went on. The nurse was unionized. Her union reported this to the employer, but the employer didn't feel like they could do anything about it for two reasons. The first one is that this is an anesthesiologist, and they are hard to come by. So if you want to that it would be a serious decision to do something with this anesthesiologist. But the second one was that the prevailing view is that domestic violence is a domestic issue and not a workplace issue. And so what happened was, one day the anesthesiologist showed up to work and stabbed this woman to death.
Oh my goodness.
And so this resulted, and the other high-profile case, I'll just say very briefly, was that a person who had been harassed, who everybody knew had been harassed for a period of about 20 years in a workplace, finally had enough and came in with a shotgun and killed a bunch of people. We're talking about Canada here. That stuff like this doesn't happen in Canada. You know, this is not the United States. And so what this led to was two things. First of all, a decision that domestic violence in the workplace is violence in the workplace.
Yeah.
And it must be prevented, because especially as it relates to violence, response is way less important than prevention.
Yeah.
Right? After somebody's been stabbed to death, it's too late to respond.
Exactly.
So, and then the second thing was, interestingly enough, they saw these two things connected. They said that harassment is also an occupational health and safety issue. And it is connected to violence. So this legislation came out in 2009. A few years later, in 2013, the Canadian Standards Association, in association with the Mental Health Commission of Canada, developed this national standard on psychological health and safety. And this national standard says that there are 13 areas in the workplace context that have the risk of producing psychological harm for workers. Organizational culture, there's a long list, but organizational culture, respect, and what they called civility at the time, clear leadership and expectations, so on and so forth, that these caused psychological harm. And this is where the ball really started to get rolling on the idea that actually harassment could be prevented. That it's not just a matter of responding to harassment and making it safe for somebody to raise a concern, but that it would not happen in the first place. Now, that's very aspirational, and the national standard was not legislation. It was voluntary. It's not a mandatory standard, still isn't a mandatory standard. But some provincial jurisdictions and eventually the federal jurisdiction picked this up and made some of this stuff mandatory. For example, in the province of Alberta, there was an amendment to occupational health and safety legislation that requires employers to protect workers from psychological harm. This is a positive duty placed upon the employer to protect workers from psychological harm. And then more recently, in federal jurisdiction in Canada, there was another very high-profile case, and this relates directly to safety and harassment. There's a high-profile case from a radio show host in a unionized work environment for a public broadcaster who was harassing female employees. All of these employees were unionized employees, and yet they did not feel safe raising this issue. And the reason why was the organizational culture, which placed a very high priority on talk show hosts, and to the extent that they didn't have to follow the same rules, more or less. This led to, there was a criminal case related to this for which the talk show host actually got off, but the talk show host was eventually fired. But this led to something else, which was called the Safe Workspaces Review. Okay. And this review was predicated on the rather alarming notion that even though there's all kinds of response to allegations of harassment, there's all kinds of protections for people who want to raise an issue of harassment. Policies, procedures, pronouncements, grievance arbitration procedures, the support and protection of the union. People still didn't feel safe. And so what they came up with is what they called Bill C-65, which was an amendment to what's called the Canada Labor Code related to occupational health and safety. And what this bill requires is that each and every federally regulated employer must conduct a violence and harassment risk assessment. And this risk assessment requires them to identify environmental risk factors for harassment and violence in the workplace, to identify present protection prevention measures that are in place, and then to assess, evaluate how well these protection measures are actually protecting people. And then propose additional protection prevention measures. And at the time, the legislation said, once you've identified these additional protection prevention measures, you've got 6 months to put it in place, or you're in violation of the legislation. Now, that was 3 years ago now. But what this, the legislation had 3 pillars to it: prevention, response, and support. And so far we've focused on prevention. But the legislation and accompanying regulations also shined a bright light on the inability of organizations to effectively respond to harassment and violence, especially harassment in the workplace, because they had not created the conditions wherein people felt safe to raise issues. You know, most federally regulated employers, we're talking about federal government here mainly, but also, you know, the airline industry and so on, had very sophisticated, quote unquote, traditional response measures, which is there's a human rights harassment policy. You file a complaint. The respondent is told that it's, you know, that any act of reprisal would go against them, so on and so forth. But there was no culture in which people felt safe raising issues like this. Everything got overly formalized, and that a person feeling as though, like, feeling that somebody is doing something that is inappropriate or is targeting them, didn't have any opportunity to have a conversation about that. A safe conversation, a safe, confidential conversation with someone before having to file a complaint. The typical answer to anybody saying, you know, let's say writing an email and saying, I feel like I'm being harassed here. The typical answer was, well, file a grievance or file a complaint. And then we'll do something about it. the Safe Workspaces review made it clear that that's just not good enough anymore. And so where we've ended up, I've talked about prevention and response, but the big piece as it relates to ADR now is support. How do you support, by the way, not just complainants, but respondents in a harassment process? Because being a respondent in a harassment process, like being a complainant, these investigation is a traumatizing experience. And so the legislation didn't get very specific about this, and I think it's likely because the legislators actually don't have a really good grip on alternative mechanisms for providing support for people. For example, there was no mention of workplace restoration, even though workplace restoration is something that is done in federal government quite a bit. That's kind of where we're at in Canada at this point, in terms of this. And what I should say about that is that our organization, Workplace Fairness International, not only have we been advocates for the changes that have been made, but we're quite convinced that they don't go nearly far enough, and that what we really need to do is evaluate the conflict management systems for a proactive approach, because so far our conflict management systems are entirely reactive. Even mediation is reactive. Something has to happen before mediators get engaged.
Thank you so very much for your insights. Yeah. I really want to ask two questions. So the first question is, from what I hear you say, are you saying that there is no strong support for ADR to be used as a viable option to settle workplace disputes, precisely on discrimination, bullying, and harassment in Canada?
Yeah, and so let's talk about that a bit.
Yeah.
One of the evolutions, especially in the provincial jurisdictions, one of the evolutions actually has to do with this case of this high-profile radio show host, and they're thinking about what happened there and why what they were doing before wasn't good enough. The evolution went from, we're not going to act until somebody files a complaint, to legislators saying, employers, you have a duty to investigate whether or not somebody has filed a complaint. There is a good logic to this in the sense that this now forces the employer to do something. But the problem is, the focus is now on investigations rather than other alternative methods for managing things. So if the employer has become aware that there is an incident or that there's a circumstance that could amount to harassment, they have a legal duty to investigate under occupational health and safety legislation. And that comes first in their minds. And they are concerned. This is relatively new legislation, by the way, and so there's not a lot of jurisprudence in the area. But the concern for many employers is look, if I try to introduce ADR or I try to introduce mediation here, I might be in violation of my responsibility to investigate. Because you don't want an investigation going on at the same time that you're doing mediation. These are processes that have mutually exclusive demands upon them. So what many employers have tried to do, and I support this move, is to have within their policy something called early resolution. So what they'll say is to a complainant, they'll say, or somebody who's raised an issue, they'll contact that person. They'll say, look, here are some of your options here. What would you like to do? And so if the complainant says, well, I'd just like to have a discussion with the other person and I'd like some help with that. Okay, fine. So we'll do that. And so it appears that if the decision comes from the complainant, then there's less of a concern about how the thing moves along. But part of the problem with that is this really consent, or is it more or less coerced consent? So you have a let's say a higher level manager or director or something who has now been accused of harassment of a worker, and the HR function contacts the worker and says, what do you want to do? This early resolution that, in which the matter will be resolved in a week, or this investigation that may go on for 8 months. And in the meantime, of course, we would have to separate you from the other person, which would have an impact on your work. And, you would have to report to somebody else that's, you may not be all that familiar with, or may not be familiar with your work. I don't know how it's going to affect your performance ratings. The list sort of goes on, right? So then it starts to look like something other than a voluntary acceptance of early resolution. So there's balance there that needs to be sought. And I work as a mediator and an investigator and a workplace restoration practitioner, and I can see how this plays out and by the way, a consultant for organizations that are trying to get get this right, and I can see how this plays out for them, that they often feel like they're in kind of a box here. They often feel immobilized because of all of these obligations that are around them, for which they don't have a really clear picture of what the standard is, because a lot of this stuff actually hasn't been litigated. But having said that, workplace restoration, conflict management coaching, mediation, group facilitation, these are all alive and well in Canada, in Canadian workplaces. They're being used all the time. They may not be used in as proactive a way as they could be used, and that might have something to do with the way especially provincial legislation has laid itself out. But from often decisions about what process is going to be used is made by those who are in charge of compliance. So they're going to say, well, what does the law require us to do? It requires us to do an investigation. It doesn't require us to do early resolution or these other things. And so the default, from a risk management perspective, from their view, the default is first we comply and then we do what we think is right, and that can have its own challenges. Like with the best of intentions, some of this legislation has caused its own challenges.
Thank you so very much, Brian, for highlighting how the laws and regulations have sort of surrounding workplace discrimination, violence, harassment, bullying have sort of evolved to help prevent these behaviors. I think we've got 5 minutes. I also want to ask this question. So what cultural nuances aid in abating these behaviors at the workplace?
Sorry, ask that again.
What cultural nuances aid in abating such behaviors at the workplace?
Well, one of the things that was identified by the Canadian Standards Association and the Mental Health Commission of Canada is that organizational culture is a huge environmental risk factor for harassment and violence in the workplace. And so, and this can be explained in a number of different ways in different industries. With the broadcaster and the radio show host for the broadcaster, there was an investigation that was conducted by a very prominent investigator in Canada, and she coined this phrase about the workplace that it was called the host culture. And what that meant was that there is a certain class of people in that workplace that had more rights and more freedoms than others in the workplace.
Yeah.
So in other words, more or less functionally, even though technically the harassment provision and so on and so forth in the policies applied to this host, functionally it didn't apply to the host because the culture produced a sense of fear amongst people who had the right to file, a fear associated with actually exercising that right. And this actually puts me in mind of something that I heard about what is required for safety. And this brings us to a discussion in a sense of a trauma-informed approach.
Yeah.
What is required for safety? So, involvement, influence, choice, agency, peer support, confidentiality. These are the kinds of things that are required for a person to feel safe to, in a culture, from a cultural point of view, to raise an issue, like a full feeling of citizenship might be a way of describing that. And by the way, citizens having not just rights but responsibilities, right? And so, you can see how there are cultural elements that will discourage people from feeling safe to raise issues about their treatment. Maybe should end off by saying workplaces across the world are legally